Hey, it's your old buddy, attorney Brian Parker, bringing you another exciting video. This actually was exciting for me. This is the first time I've had this particular plaintiff or debt buyer, and it is a new one that I see on the East Coast a lot, but this is my first, and has an interesting twist. It's called, the name of the debt buyer is called 2023-1 Prime Consumer Loan Trust. And while it has this trust sounding name and perhaps is intimidating, it is just nothing more than your average debt buyer case. And what do we mean by that? Well, what do we do with debt buyer cases? I haven't done this in a while. What's my mantra? Hello? Hello? That's right. Use their documents against them. I think you're in for a treat today because we're going to use their documents and more specifically their pleadings and this chilling affidavit that they have attached to prove their case. But as I always say, when they provide more information, they provide more problems. And that means you're going to do well. So what I want you to remember is a couple of things. We always first tear apart the pleadings. So here's a couple of words of advice. First, we look at the dates of everything. When was something signed? When was something assigned? When was something transferred or sold? Write down all those dates. Then, when you rip apart the complaint and the affidavit, do they match up together? Is the affidavit, this is important, claiming to be supported by documents? Courts will look at an affidavit beyond what it says, because anybody can say anything and sign anything. So if it refers to documents, it's fair game for you to go, hey court, they're relying on documents that aren't attached to the affidavit. So is the client, your client or you, being called a defendant and their side being a plaintiff well before a lawsuit is even filed? See every case I've ever been involved in 30 plus years. Yeah, bringing 30 years in about 30 minutes to you. Is there a claim of an assignment, but no assignment? That never happened, right? Said nobody ever. It happens all the time. They'll attach things that they call transfer of assignment, but they just don't match up. Maybe does the thing match up should be the theme for today. But actually the theme for the day at the end will be, you can't make this up. I'm sorry, but you can't. And you'll see in a snarky email I said at the end that I sent to the law firm here, which is a popular one, Zwicker and Associates, which is throughout the nation. I think they and Mandarich are the most, they have the largest presence in the most states. I see them all the time. So we tear apart the pleadings, and I'm going to show you their first page and their first mistake. Cindy put up page 1 of 3 in the lawsuit, Shazam. And you can see the plaintiff there is saying, and I'm reading to the side, so if I don't always make eye contact, forgive me, I just want to do a good job. Plaintiff was assigned defendant's loan after origination by Goldman Sachs Bank USA. As I've counseled you in the past on FinTech and these personal loans that are now proliferating throughout the nation, they have their purposes, business and personal wise. There is an origination. An origination means you signed up for a debt, the debt is complete, both parties have agreed to it, you get your check, the debt was originated. So that's a term of art for trust securitization. You see the word origination, that means something is being originated and sold into a trust generally. As you can see up there, the Systems and Services Technologies, SST, is the servicing entity for plaintiff. There's no proof of this. After you look and see, and this is the analysis I'm going to give you is a general analysis for your state and your facts that applies just about every debt buying case. Go to my membership site, collectionstoppersolutions.com. It's a good deal right now, really good deal. We've got over 180 videos on there. and templates and instructions. You have to look at this face and my show notes, which I'll make available for this case. There's 1, 2, 3, 5 page, 6. There's a lot of show notes. So I review the documents here. You've seen what they say. There's no evidence that the loan from Goldman Sachs was sold to the plaintiff. We're going to call them PCLT, because I don't want to keep saying 2023-1 Prime Consumer Loan Trust. The only good thing about that, it reminds me of all the cases I did with National Collegiate Student Loan Trust and whatever date or year they claim to own the debt. A good quick pro tip. Trusts aren't necessarily good plaintiffs. There are states in our wonderful union that don't allow a trust to be a plaintiff. So if you're in one of those states and there's a trust in the caption, check it out. It may not be allowed to be there. It generally has to be, any trust makes its movement or its actions through a trustee. So there should be an agent or a trustee in the caption. This is not the case here, but they get away with it in Michigan. This is a Michigan case. There's no evidence anywhere that this debt was serviced by SST, System and Services Technologies. Why is that important? You're going to find out. Okay, so at paragraph 11, the company is claiming that an affidavit supports the paragraph 11 and also this lawsuit. So in these cases, whether there is the actual original agreement or contract, it's important for most debt buyers to have an account stated affidavit. So you see my mini videos on how you handle account stated claims. Let's put a couple up there, Cindy. Account stated claims. Can we do that? Swirly, can we do that? Does that work? It has to go back inside, but I know I can do this. Those are all the videos on ASS, account stated statutes, Shazumsky. Those are gone. And in this case, and this is what debt buyers do, they've titled the affidavit with their own thing, and I talk about how they use flowery language and weird words to dignify the dreck that they're signing under oath. Here it's called an affidavit and certification of amount owed. It's just nonsense words that kind of affidavit doesn't exist. But I guess you can make anything up. Remember again that I just said that about the end of the video and the fun thing I'm going to do with the snarky email. So here, Cindy, put up the first page of the affidavit and certification of amount owed, Shazumsky. And that's a Jeffrey Young from Buchanan, Missouri, we're in Michigan, claiming to be the guy with personal knowledge of SST's regular practice and procedures and putting together Goldman Sachs loans. So two things that are wrong with that, and I've even written this down, it just occurred to me. He's not saying SST obtained the right to say any of this. So who's he? And Goldman Sachs doesn't own the debt. They've sold it according to the complaint at number 1. Plaintiff was assigned defendant's loan offer to origination. So why is Goldman Sachs even part of this deal? So let's look at some of the paragraphs of the affidavit they attach to support their dreck of a case. Look at number 5, Cindy, Shazam. And that's GS is now they've brought Goldman Sachs down to 2 letters, GS. They should disappear because they don't exist here. Transferred loan servicing responsibilities to SST. Said nobody ever. My client, up until she defaulted, was making payments to a company called Marcus just at the end of last year. Marcus, if you've taken out a Goldman Sachs loan, Marcus is their servicing entity. So I don't know who this SST is. It reminds me of the Concorde. Anyway, so there's no evidence of SST receiving the right to do any of this. Here is the wonderful thing in this lovely, lovely affidavit. Because I spent 4 hours on this case yesterday. I just got jacked. I did a lot of stuff that makes me more focused. And I got jacked, man. I went deep on this one because I just, I love this affidavit. So they keep referring to the plaintiff. And that, as you know in the past with my videos, is a whole plate of wrong before the lawsuit's even filed. So no one's a plaintiff and no one's a defendant that they refer to. This is the cool thing. Cool because that's what gets me jacked, is they don't say the name 2023-1 Prime Consumer Loan Trust in their affidavit that supports 2023-1 Prime Loan Consumer Trust or whatever as being the real plaintiff here. This affiant, Jeffrey Young, is really locked into GC and SST, and he's FOS as far as I'm concerned, and he's sworn under oath that he is. But shouldn't the guy who is signing under oath know the name of the plaintiff? So Cindy, put up the affidavit from lovely Mr. Young, Shazam, and I hope it comes through. I'll attach it to the membership website. There's no name Prime Consumer Loan Trust 2023-1 in an affidavit that's supposed to support it, the lawsuit. So in his affidavit, he says, and I got to look up, sorry folks, defendant's loan has been sold or assigned to Goldman Sachs Bank USA to plaintiff, and a copy of the assignment is attached to Exhibit C. That's important. Why? Cindy, put that up, number 13, Shazam. And when it is right there in Exhibit C, he's saying, go look at Exhibit C. Remember we talked about an affidavit, if it is relying on other documents, this is the case throughout the land, you have to have the documents attached that you rely upon. Otherwise, you could make stuff up. It's just supporting documentation that eliminates the hearsay of, everything is hearsay, by the way, unless you have an exception. And normally stuff like this comes in under the business records exception, 8036, put your state nomenclature before that. In Michigan, it's MRE, Michigan Rules of Evidence, 8036, exception to hearsay, business records. So you've got to show it, to say it, and have it be before a jury or a judge. So he says, go to Exhibit C. So you go to Exhibit C. Let's go to Exhibit C, Cindy, the top page of loan purchase and sale agreement. Shazam. There it is. It says right there, loan and purchase sale agreement, Goldman Sachs selling the thing to 2023-1 Prime Consumer Loan Trust. How come the affidavit doesn't know that? How come the guy that signed the affidavit on June 19th, 2024 doesn't know back on March 29, 23, the name of the plaintiff, Prime Consumer Loan Trust 2023-1, and it says purchaser, yet in their number 13, put number 13 back, Cindy, because this is important. I'm pointing up, you can't see that. I'm pointing sort of there. Defendant's loan has been sold or assigned by Goldman Sachs. Now, if I sell you my car, you wouldn't say you leased or purchased it because you purchased it. Why would you say that? So if you know you did something or something was done, A, you'd know the name, Prime Consumer Loan Trust, would be in your affidavit. Number two, you knew that you bought it as opposed to transfer or assigned it. Why does he have to have wishy-washy language if something is the truth? Because, think about it, this is a one-size-fits-all that they just sign off on. So it's got to fit in there. So he doesn't know that, but he's referring to Exhibit C. Exhibit C is not attached to his affidavit. Exhibit C is attached to the complaint that's filed days and weeks later after he signed under oath. So what is he referring to? It doesn't exist until it's filed. So, and yet he hasn't read it, because if he had read it, it would be in his affidavit who the plaintiff is and that it was purchased. This is stuff my brain loves to eat up for dinner. So you're going to hear a lot of buzzer sounds today. Here's another one. Mr. Young had supposedly access to all this information, all the purchasing, the names of everybody, and he just goes bad, and he does not even know that the lawsuit has been filed yet, but he's talking about it before it is filed. And there is the governing law provision of the agreement he refers to, he calls it Exhibit B. And the governing law provision says he can file it right here in Michigan. No, he doesn't. The governing law is Utah or federal law, which means Utah, where most of these debts are coming from. The case has to be filed in Utah under Utah law. Even if it's in the state you're in, it has to be under, and they have done none of that. So you come across these cases and you go, there's no way they're making up. Excuse my language again. So we've looked at how this company is claiming to have purchased something their own documents show that they have not. We've looked at the affidavit supporting it. We've looked, and I'll put up the lawsuit, attach it to this video. The reason you tear this stuff down, and let me tell you those questions again. What are the dates of anything that is filed, served, sold, transferred, or signed? Remember, he signs an affidavit before the lawsuit is signed and served. He's claiming something is signed or sold when he's clearly aware that maybe something has already been purchased. This is what you ask these questions. Do the pleadings and affidavit match up? It's there for a reason. Here they don't match up, and we've showed you why. Is the affidavit calling the client a defendant and themselves a plaintiff? Yes, again. That's why I ask these questions. That's why you analyze these things. Except here, weirdly, they don't even name their own plaintiff before the lawsuit is filed. Is there a claim that the debt was assigned when there's no proof? Yes, there's no assignment of my client's debt from the original creditor at origination to whoever is suing my client. And if you read the affidavit, we don't know. The affiant thinks it's Goldman Sachs and he's allowed to service it. There's no proof of that. Are there mistakes in the pleadings? Hells yes. That's what we bank on, and they always make us happy in that regard. So I've showed you everything I've got. I took everything I showed you, plus more, and put it into the counter affidavit, how to defeat this company using their own documents. And you use that affidavit to go into your answer, to go into your affirmative defenses, to go into your counterclaim. This one's going to get one, because this law firm, while they're respectable, they're knuckleheads when it comes to looking at the proof and the truth. The proof and the truth. So on my membership, you will find a couple of things. The actual lawsuit that my client faced, my answer, the very important counter affidavit, everything I just told you and more from the pleadings or your analysis. That's the first document, is the counter affidavit. And that son of a gun will follow you no matter what thing you face. Get that counter affidavit done. For example, when I do my counter affidavit, I have two screens. One screen has the counter affidavit, and here's the answer. I transfer everything, because it's already done. I already did in the answer. So I'll put up the answer in Word and the counter affidavit in Word, so you can see how I do that. The counter, I can't stress this enough. You use their documents against them, put it in the counter affidavit, and you can use that in response to motions, filing motions. I just filed a big motion today. Took the counter affidavit information, dropped it in. All my work is done. So please hear me on that. The counter affidavit is everything in that regard. You'll see the affidavit of this Mr. Young signed under oath, and I don't know why. And you'll see my show notes. You'll see the stuff that you need in Word templates to be a success using your own state laws and facts. Now, here's what I did. Excuse me. Here's what I wrote to the other side. Good afternoon. Attached, please find the responsive pleadings of my client. Their response to a perjurious perjurious affidavit with a lack of personal knowledge that was signed under oath almost a month before the lawsuit was filed, but calls a mysterious entity not mentioned in the affidavit a plaintiff and my client a defendant before the lawsuit is filed. The expression, "you can't make this up," comes to mind, but clearly someone did. Let's take a look at the dreck of a lawsuit you filed. Am I snarky? Yes. So the affidavit attached to the lawsuit was signed under oath. The plaintiff is owed money by the defendant on June 19th when no plaintiff or defendant existed. The lawsuit was not filed with the court until July 5th. While the word plaintiff is used in the sworn affidavit, the actual company you represent is not mentioned anywhere in the affidavit. Keep in mind, it's more than likely that this affidavit was written most times by the law firm for this affiant to just sign off, sign off, sign off. I used to do depositions of a very big deck buyer, I won't say who, out of Minnesota. They'd have a mill, man, and there were a lot of class actions that hopefully stopped that a little bit, but this clearly is a mill one. And I point out Exhibit 13, the affidavit number 13 is just dreck. There's no Exhibit C attached to the affidavit, as I said. The lawsuit's not been filed yet. Why does the affiant not mention who the plaintiff in his own affidavit? He's looking at the complaint Exhibit C first. In other words, if the affiant is swearing under oath he's witnessed the computer records in this case on June 19th, where is the mention of Goldman Sachs assigning the debt to Prime Consumer Loan Trust, as you claim in your lawsuit, and the date it happened? Does not exist in the sworn affidavit. Where's the mention of how SST obtained the servicing? Why is Prime Consumer Loan Trust or SST not mentioned in the loan agreement? That's another thing. The actual loan agreement does not have this company, Prime Consumer Loan Trust, or the servicing entity. And it probably wouldn't if the client had not defaulted. But where is the evidence? I'm searching here, and the proof and the truth for this entity to be suing my client and this other company saying they're servicing it. There's just nothing there. Why are you calling a loan and purchase and sale agreement an assignment in your lawsuit, but without a date or the name of my client when there's no evidence of the specific loan in this case being assigned? Your documents that my client's counterclaim will be based upon are, in a couple of words, very truth challenged. Does your affiant know what it means to sign to the truth of something that has not happened yet? Or that if he had personal knowledge of the case, he would mention the name of your client in his own affidavit? So I take it back. You can make this up. So your lawsuit's based on junk paper and a plaintiff affidavit that violates the oath it was sworn under. And it's a whole plate of wrong. Please dismiss your lawsuit by September 11th, 2024. I will file a counterclaim on the above and more. See my client's counter affidavit. Thank you. So snarky email, you can use it or just laugh. You can have that attached to the video I'm creating today. I'll drop this sometime later today. I thank you for your attention. I hope that's helpful of a new one, 2023-1 Prime Consumer Loan Trust. I keep repeating that because clearly the people that are representing them need to know who their client is, because it's nowhere to be found in the lawsuit against my client. Thank you very much for your time. Like, love, and subscribe. Go to the membership site. Oh, tomorrow, today's Thursday something, the 5th of September, I think. And then tomorrow we're bringing back the question and answer. So come and see us on YouTube, I believe, and ask any question you want. Well, keep it collection related, please. Nothing about my hair or the quirky way I behave. I'm doing it all for you. Thank you. Bye now.